Good evening and welcome to the inaugural session of the 6th CIRC Biennial Conference on Competition, Regulation and Development. This year's theme is Making Competition and Regulatory Regimes Matter in an Increasingly Online World. At this inaugural session, we will be setting the context as to the role of competition and regulation in fostering development and reducing inequalities. With this said, I'd like to welcome on stage the chair for this session, Mr. Pradeep S. Mehta, Mr. Jay Panda, Ms. Sangeeta Verma, Mr. George Lipimile, Mr. Amit Kapoor, Professor David Gerber, and Dr. Arvind Mayaram. While Ms. Verma joins us, I'd like to make a few house announcements. We would be webcasting this session live on Facebook, as well as doing live tweeting of this session as well. If you are on Twitter, please use hashtag CUTSBiennial to tag us, and also tag our Twitter handles. CUTS CCIR's Twitter handle is at CUTSCCIER, and CIRC's Twitter handle is at CUTS Institute. You can also find the hashtags and the Twitter handles at the top of the agenda as well in your folders. I'd like to now invite to the podium the chair, Mr. Pradeep Mehta, to begin the proceedings.
Thank you very much, Shagufta. And with that, let me also join Shagufta in welcoming all our distinguished guests on the panel, particularly Mr. Jay Panda, former Member of Parliament and the national spokesperson for the Bharatiya Janata Party, the party which is in partnership with few other parties is ruling at the center and various other states. I'm indeed very thankful for your finding time from your busy schedule to be with us. It has been always a privilege to hear Jay speak. He has been on our platform and promoting competition and regulation, better regulation on various occasions. He's been a member of parliament for long as well. In the last election, he did not succeed, but I'm sure he's going to come back into the parliament as it is something as it is natural to him. Now, let me also welcome George Lipimile, the Executive Director of COMESA Competition Commission, who is considered to be a champion of competition law and policy in Africa. He has not only set up the Zambian Competition Authority, but also helped to establish many other competition authorities. And at the moment, he is running a regional competition authority of one of the biggest regional economic cooperation systems in Africa, the Common Market for East and Southern Africa. It starts from Egypt in the north and goes right down up to Zambia and Malawi in the south of Africa, and expanding. Amit Kapoor, we start off with one Amit Kapoor in this opening session, the chairman of the Institute for Competitiveness, and we close with another Amit Kapoor, who's a lawyer, in the valedictory session tomorrow. So I'm glad there was no confusion about the same. And another very extremely brilliant analyst in many ways, done a lot of work in terms of competitiveness particularly. Dr. Arvind Mayaram, former Finance Secretary, Government of India, and Chairman of the CUTS Institute for Regulation and Competition, and a very dear friend since many years. He is also currently the economic advisor to the Chief Minister of Rajasthan, Ashok Gehlot. And under his guidance, there are a lot of things which are happening in Rajasthan, which, of course, he doesn't take credit for being just the advisor. but a great asset for economic reforms in Rajasthan. And I'm sure he's going to promote competitiveness as well as we move along. Sangeeta Verma, a member of the Competition Commission of India. She has been in the Indian Economic Service, and that is how I have known her since quite some time. And she now is the member economics in the Competition Commission of India, which is a kind of a tradition which the Competition Commission has followed in order to appoint members judicial and members economic along with others in the Commission. And David Gerber, a scholar from Chicago, who is another very old friend in the competition community that I have had in America. And I think it will be evident. His skills and his scholarship will be evident when he speaks in this particular session. So we have an excellent panel at this as we stand today, and in order to kick off something which is extremely critical and new to the developing world. How do you deal with competition issues in the digital economy, which itself is something new, which is going to what we hear about. And more than half of the world today is online today. The internet economy is changing lives in developing economies in a manner never imagined before. And the progress which takes place every 1 year catches up with the progress which happened 10 years ago. I mean, the speed of progress is so fast that you don't know, as we call it, the disruptive economy. Digitization fueled innovation is creating innumerable income generating and job creation opportunities, while also stoking fears of abuse of power, discrimination, and increasing inequalities. Despite the inherent capability of internet to connect and reduce distances, I've often called internet as the next biggest revolution after the wheel was invented, in terms of the motion, the mobility of people in order to communicate. And now what is happening today in order to deal with the vicissitudes of internet, of which there are many, countries are increasingly considering restricting movement of goods, services, persons, and data. Many countries, including India, are considering data localization from this. Not only that, but there is also a trend of deglobalization added with this. So it's a kind of a little murky situation. Globalization is being challenged. The World Trade Organization itself is in peril for various reasons, but I'll not go into those reasons here, except to say that there is a lot of things happening which are beyond our understanding at this. At the same time, developing countries particularly, are moving beyond mere GDP as a metric to measure economic growth, and are keen to focus on clean, sustainable, and inclusive development. You also have the global issue of climate change knocking on our heads, the kind of weather changes which are happening, another very disruptive manner in which things are happening. My friend Alan Asher from Australia was just telling me that large amount of bushfires have taken place, and so Sydney is like Delhi in terms of smog. So it is not as if Delhi or parts of northern India, which includes western Pakistan, are deluged by smog, smoke and fog, and a lot of people are falling sick also because of that. Now, that aside, so the challenge of sustainable and inclusive development also then knocks as to how you're going to look at economic growth in terms of pure mercantilist approach, or you're going to look at it through a totalitarian approach in terms of balancing both equity as well as ecology. Developing countries, particularly those who have not yet attained reasonable per capita income levels like India, or have not been able to benefit from the global value chains as yet, may face immense pressure from these developments. There is a lot of movement happening in many parts of the world, some kind of an autarkic approach that you consume food which you grow locally. For example, I mean, they may not be in a position, developing countries may not be in a position to rely upon open markets for rapid economic growth. At the same time, they might be expected to do more to ensure that their growth is cleaner and non-discriminatory. If not carefully handled, years of effort towards social and economic progress runs the risk of being stalled as a result of these developments. What is the role of competition and regulatory agencies in this kind of situation? Competition and regulatory regimes are typically hailed as tools to guide fair markets to function efficiently and promote economic growth. That is the goal which has been set, and this is what we have learned in our own lives. However, the form of these tools, as we know today, was formulated in another era, when digital economy was very nascent. The only success of digital economy I could remember in the last 15 years was the M-Pesa in Kenya, for example, through telecom. Telecom did help mobile telephony. But the kind of thing what happened was something which has now become a model for the world. It is not yet clear if these tools can be used to navigate effectively increasing online and digitally enabled environment we live in today. Or do they need to be altered? Or is there a need to design an altogether a new toolkit? These issues are subject to intense debates in advanced economies. The whole US Congress, Parliament, as well as many states are looking at the challenges of these big tech companies. And so, there's a very, very vigorous and a live debate happening in many parts of the world, particularly in the US. We are going to hear more about it from David. Obviously, these debates occur in the context of evolved institutions, effective government-citizen engagement, and institutionalized practices in such advanced economies. Despite having experience and expertise on their side, developed economies are far from reaching a consensus on some of these issues. Did competition agencies in advanced economies acted late in applying merger regulations, thereby reducing the possibility of competition in the online market? Or was there absolutely no evidence of consumer harm for them to act? Question one. Question two, is consumer welfare restricted to availability of products and services at low prices in short term? Or should non-price factors and possibility of price increase in the longer term be taken into consideration while analyzing the level of competition in online markets? Particularly a question to Dr. Sangeeta Verma. Can network effects, the third question, can network effects and access to data be considered as features and not bugs of an online economy? Or should they be considered barriers to entry? Fourth, have big tech achieved too big to fail status? And thus intermediation should be considered utility status, or users are merely rewarding them for their innovation and risk-taking ability? Number five, are ex-post fines on big tech adequate remedies for alleged violations, or is there a need to reimagine their accountability mechanisms in a manner that benefits to economy are not lost sight of? What is the special case for developing countries? And this is what is the theme and the focus of this particular conference. While advanced countries continue to deliberate, we in the developing world cannot sit idle and wait for them to reach consensus. In any case, we cannot blindly adopt the principles, concepts, and regulations formulated by them. This is we've seen even in simple competition law regimes that we cannot, there's nothing, one size fits all, does not fit all. We have to often tailor our own legislations to deal with the issues which are different than what happens in the advanced economies. These issues need to be tested on unique capacities, requirements, and objectives of each of the developing countries. And each one of the developing countries will have to devise their own path to foster an online economy, which are also dealing with challenges of generating adequate income generating opportunities. A digital economy, for example, in Africa is progressing very fast. But the competition legislations are just not designed or tailored to deal with the kind of abuses which may happen. Now, when compared with advanced economies, competition and regulatory regimes in the developing economies are still in infancy and are yet to gain maturity. While some countries like India have had competition law for more than a decade now, albeit with the absence of a sound competition policy, Angola has adopted a competition law last year. Despite having a competition authority at the regional level, 4 member nations of the COMESA treaty do not have competition laws. Similarly, good regulatory practices like repository of regulations, structured public consultation, notice and comment period, cost-benefit analysis, sunset clauses, etc., have not been institutionalized as yet in most of the developing countries. Even in cases where experience and expertise exists in developing countries, independence and enforcement capacity may be missing or be subject to stronger political will, thus possibly making such institutions subject to capture. I mean, vested interests do operate in all economies, and particularly in the developing countries, they are much more influential than in the developed economies. With the entrenchment of online economy, the interface between competition and sector-specific regulatory regimes such as agriculture, pharmaceuticals, mobility, retail, particularly e-commerce, has increasingly become intense. New issues like lack of privacy protection, cyber attacks, discrimination, inadequate considerations to human rights and ethics are now coming to the fore in terms of the discussions. It is encouraging to note that developing countries have started to consider some of these issues seriously. India recently acknowledged the right to privacy as a fundamental right and considered the constitutional validity of its national identity scheme, which is called Aadhaar. In fact, my friend and our chief guest, Jay Panda, introduced India's first private member's bill on right to privacy in the Indian Parliament in 2017. Kenya is currently considering constitutional validity of Hudumba Namba, its own version of a national ID scheme. The Jamaican Supreme Court, on the other hand, has struck down a national biometric ID system. All this is happening because developing countries are starting from a clean slate and not waiting for the advanced countries to show them the way. Is this the way forward while considering other competition-related issues that I touched upon a while ago? I'm not sure. We at CUTS are playing our part by implementing larger user-facing studies to collect and analyze user perspectives, perceptions, and experience on these issues. Key findings of our studies are available with all of you in the pen drives in your resource kits, and some publications are also there. The interface between online and offline economy and how regulation and competition regimes will ensure a balance between them is also something to look out for. For instance, will the scope of relevant markets, as traditionally understood under the competition law, be limited to online services or be extended to cover offline services as well? Now, we are talking about two-sided markets, and we will look at taxi aggregators. There's probably a four-sided market. If you look at the driver element, which is, I'm told the drivers of Uber and Ola taxi service are going to go on strike tomorrow. Just a little aside, so please take care of you. We at CUTS are playing a part by implementing the interface between online and offline economy and how regulation and competition regimes will ensure a balance between them is also something to look out for. Sorry for repeating it, but for instance, will the scope of relevant market as traditionally understood under the competition law be limited to online services or will determination of relevant markets, particularly in case of aggregators and platforms as I spoke, require investigation from supply as well as the consumer side, given the nature of multi-sided markets? Even the need to define relevant market itself may need to be considered. The Government of India has set up a competition law review committee which has recommended in depth as to how to cover many of these issues, and the recommendations will be captured in an amendment bill, and we hope that it will come to the Parliament in the next session. We have recently undertaken an evidence-based study on determination of relevant market in ride-sharing industry with a focus on Delhi NCR region. covering these issues, and we'll be releasing our findings very soon. How developing countries decide to deal with these issues will determine the course of global online economy, given that these economies will soon be the largest markets for online service providers. Let me now come to my conclusion on the importance of this conference, as I said earlier. It is for this reason that the 6th Biennial Conference organized by CIRC and CIRC and is being held in New Delhi with almost equal participation from developed and developing countries from around the world. I've just scratched the surface, and we must collectively deliberate these issues along with all its facets to discuss the way forward for optimal regulation and competition for an increasingly online world. And let me underscore the word optimal, because often we tend to get into maximal regulation with the result that we kill innovation. And that is happening in many areas. Before concluding, I must thank you from the bottom of my heart for participating in this conference, and there are more people who are going to join us tomorrow when we have these substantive technical sessions. I assure you that your contribution will not go unnoticed, and a dedicated team at CIRC and CIRC will be working to design and pursue action agendas from the discussions at a global level. Furthermore, we are also celebrating the World Competition Day on 5th December on issues being discussed in the conference. I urge and request all competition authority representatives and friends of competition to participate in the campaign to adopt the World Competition Day on 5th December. This is an event which we've been partnering with UNCTAD and many other countries. The happy news that I have to report is that the government of Philippines has adopted this as their National Competition Day. With that, let me now conclude and request Dr. Sangeeta Verma to please address the gathering. Thank you.
Dr. Pradeep Mehta, DG CUTS International, distinguished panelists on the dais, and friends. It's indeed a privilege to be here amongst all of you today on this important discussion with regard to regulation development. I must congratulate CUTS and CIRC for encouraging tremendous scholarship on this area. They have been doing work on this area for a long time, and this is also a continuing series of debate and dialogue. So it's really encouraging to see that this kind of dialogue is being encouraged, and especially in the context of a developing economy and the developing world. Insofar as the developing world is concerned, there are a number of challenges that have come up recently. And you will give me a moment to organize my thoughts, because I have managed to. And what's especially important, why it is important that a developing world should be looked at separately, is that a number of the developing economies, we are in transition. And in this transition process, we are trying to leapfrog developmental activity and cut short the developmental track, as a result of which there's a lot of experimentalist energy and creativity within, much of which will need to be brought to the anti-enforcement activity of these jurisdictions. What is important to keep in mind is that our economic structures, that is those of the developing world, our infrastructure, our economic structures, the expectations of our citizens, institutional, political, ideological, and legal conditions in our countries are different from the Western world, where the antitrust doctrines were first developed. So the crafting and enforcement of competition law needs to take into consideration the inherent characteristics of the developing worlds. But what is important is, as Robert Bock explained in the antitrust paradox, and I'll quote this, antitrust policy cannot be made rational until we are able to give a firm answer to one question. What is the point of the law? What are its goals? Everything else follows from the answer we give. Only when the issue of goals has been settled is it possible to frame a coherent body of substantive antitrust rules, and unquote. So yes, goals do matter in antitrust. The two broad goals that predominate modern academic and policy discourse are total welfare, that is the overall surplus from producers and consumers, and the consumer welfare, that is surplus only from consumers. And the goal that we select matters to the execution of antitrust law. This is particularly true when there are per se rules, there are no per se rules, regarding legality and illegality. So from the Indian context, let me attempt to answer, do we need to revisit the traditional understanding of the consumer welfare approach? There is today, in many commentators across the world, there is an understanding and a view which is gaining ground that consumer welfare standards should be abandoned. That is one of the questions that this particular conference has also posed, and that a host of new factors may need to be added to antitrust policy to address, such as vibrant small businesses, innovation, privacy, workers' interests, etc. Many jurisdictions do adopt multiple, even mutually conflicting goals. But in the Indian context, in India, the preamble to the Competition Act 2002 articulates the objectives to be pursued by the Commission. So I will just, for the benefit of the gathering here, very quickly recapitulate what our preamble says. It says, to prevent practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interests of consumers, to ensure freedom of trade. So the Act explicitly mandates the Commission to protect the process of competition, consumer interest, and to ensure freedom of trade for businesses. And how do we go about it? So what is the legal test laid down for determination of illegality of agreements or mergers? That is the appreciable adverse effect on competition. And how do we determine that? It's important to know that. It's important to see whether the test provided for assessing AAEC, that is the appreciable adverse effect on competition, does it allow for anything other than economic factors? So let me very quickly speak about them. There are three aggravating factors. These are laid down in section 19, subsection 3 for those who would like to take a look at it. Most of you would be aware. So there are three aggravating factors which relate to the restriction on process of competition, be it through erection of strategic entry barriers or ousting of competitors. We in the CCI we view the limiting of competition as a precursor to or a cause of reduction in consumer welfare or allocative efficiency. Then there are mitigating factors. The mitigating factors again relate to other efficiency considerations and the consequent accrual of benefits to consumers, that is accrual as a result of those efficiency considerations. So depending on the facts of each case, it is essentially a balancing exercise between the mitigating and the aggravating factors that the Commission carries out to arrive at a conclusion of AAEC. So you can see, as is evident, there is no non-economic factor that finds a mention in the AAEC test. So goals such as protecting small businesses, promoting domestic firms, public interest considerations are not stipulated in the Competition Act 2002. They are not pursued by the Commission either, in either our antitrust assessments or our merger reviews. And I must emphasize that, as Mr. Pradeep Mehta mentioned, there was a committee set up to review the competition law, the Competition Law Review Committee, and this has also argued for the continuation of an effects-based analysis based on economic factors. With respect to merger review, the AEC framework of the Act allows the Commission to consider the benefits of the combination and whether these benefits of a merger outweigh the adverse effects of a combination on competition, if any. So again, we do a balancing exercise, and our decisional practice has been to assess the effect of a combination on competition and the ability and incentive of the merged entity to raise price, degrade quality, or affect innovation. We found that efficiencies are not usually measurable. They may also not be specific to a merger, so as to allow for a very specific balancing exercise. But wherever we are assessing the effect on innovation, wherever the underlying premise has been that the consumers would ultimately benefit from the innovation. Thus, the effect on consumers, we can say, has been at the heart of the merger analysis also. So at CCI, we believe that the consumer welfare standard, properly defined, protects all counterparties from anti-competitive behavior or transaction. Both price and non-price effects are incorporated. Non-price effect in the form of lower quality, reduced variety, or slower innovation, thus allowing regulators and courts to focus on long-term changes. Pure static price metric effect for the assessment of a conduct or combination is now passé, and various considerations are incorporated in a sound competition assessment. But distribution concerns, and I'll repeat this, distribution concerns still do not enter these considerations. In our view, it is important that antitrust policy remains focused on market activity and is backed by a clear economic analysis of likely effects. We will continue to focus on those types of conduct that are most harmful to consumers. Looking at new age markets, there's no doubt that digital evolution of the economy is a welcome step, as it helps in ensuring transparency, accountability, and informed choice by a consumer. I need not elaborate further to this audience. At the same time, the nature of the online economy is throwing up a lot of challenges. It has posed new questions, and not just to the manner in which businesses are functioning, but also to the regulators, and whether and how free and fair competition is functioning in the digital economy. So the question that arises is, what should be the role of the antitrust regulator in digital markets? In markets which are primarily driven by innovation. Does dealing with the disruptions and innovation-led markets warrant a different or modified antitrust approach? So we all know that the digital economy is identified by characteristics of increasing returns to scale, platform models of business, backed by huge data, which leads to even further accumulation of data, meaning thereby that in a digital economy, network effects could prevent a superior platform from displacing an established incumbent. The size of this incumbency advantage, there is an incumbency advantage, but what all does it depend on? It depends on a number of factors, such as the possibility of multi-homing, can people go to more than one platform, data portability, and data interoperability. So these are issues that we need to look into when we assess cases under the new economy. Given the structure of the market, of the new age markets, and given that competition may not be feasible at times, demand side efficiencies can be harnessed by a dominant firm alone. So there's also a line of thinking that maybe some of these markets may eventually need to be regulated akin to a public utility. Second, this shift of economic transactions from brick and mortar to digital space has implications for businesses, consumers, and markets. The digital platforms are creating opportunities for new businesses and business models. They're increasing transparency in online intermediation, and they are reducing search costs for consumers. But at the same time, what is happening is that the increase in the proportion of online buyers and economic activities is throwing up certain challenges for, as I said, for business as well as for regulators. For example, the distribution landscape is altering rapidly, and Dr. Mehta alluded to this, and it is altering rapidly and fundamentally. So these developments, they may prompt enterprises. How do enterprises then react to this? So they may prompt enterprises to resort to contractual restrictions or vertical restraint on dealers and retailers in the form of selective distribution agreements or exclusive of online players. Some may get into selective agreements, others may just exclude pure online players. So these are issues that we then need to confront and address. So we therefore, as a regulator, need to understand how the online markets are functioning. So to understand the market structure of, say, the e-commerce market, the regulators conduct market studies, as Dr. Mehta also mentioned, that CUTS is also doing the same. So CCI recently conducted an study on of the e-commerce market to understand how the market is functioning, how it is growing. And the interim observations are on our website, and they reveal that the online marketplaces pursue aggressive growth strategies, which could involve deep discounting, which is much in the papers, and imposition of restrictive conditions, such as parity requirements on manufacturers and service providers. Marketplaces may also be providing preferential terms to certain sellers engaged in retail to the disadvantage of other retailers. One of the challenges that regulators face, and again Dr. Mehta spoke of this at length in his inaugural words, the fact that digital markets are often two-sided or multi-sided with strong network effects. So these pose a challenge to the traditional approach to market definition. How do you define the market? How does the regulator define the relevant market? One question often raised in two or multi-sided platforms is whether the relationship between the platform and the respective market sides, let's say a retail platform and there is the shops or the vendor side and there's the consumer side. So whether the relationship between the platform and the respective market sides should be considered to be separate, or whether there is a single market. And to very briefly discuss how we in the Commission have looked at it, we look at these things on a case-to-case basis, seeing how the market is evolving. So in the RKG, hospitalities and Oracle stays, we highlighted the fact that OYO and other similar players primarily operate as a two-sided platform, connecting budget hotels on the one side with potential consumers on the other side. The Commission held that since the case pertained to a complaint raised by a partner hotel, the complaint had come to us from a partner hotel, so the relevant market determination would need to take into account all alternatives available to such budget hotels. Where all can they list? What are the alternatives available to them? And the competitive constraints that they face, faced by the focal product. That is the service that OYO is providing to them. So the Commission noted that what OYO offers to budget hotels is essentially a franchising service, comprising a bouquet of services, which enables the franchisee hotels to reap the benefits of the OYO brand in return for a commission or share in revenues, while ensuring minimum monthly guaranteed revenues to the partner hotels. So that is what OYO was doing. And in this light, in light of what the focal service was, in light of the fact that examining what are the alternatives available to these budget hotels for that kind of service, the Commission defined the relevant product market to be the market for franchising of budget hotels. So the reason for me to speak about this was to say how we have been looking at things as the market has evolved. Another issue that troubles competition enforcement in platform markets is that whether a platform can be viewed in isolation of the other side, or is it always necessary to take into consideration both the sides of the platform while delineating the relevant market? In the Google case, the Commission answered the question by holding that the two sides of the market, both sides of the platform, complement each other and are interdependent. This was the consumers and the search platform. Predatory pricing is another antitrust concern that haunts the digital economy. CCI has also dealt with such cases relating to this allegation. In a case of fast track call cab, Meru versus ANI Technologies, which is Ola, we examined this issue. There was an allegation of predatory pricing, but the Commission did not see the need to intervene because we found that the market was still evolving. So the regulator, as we go along, Mehta Saab, is taking a view on where and what level the market has reached. So we felt that the market is still evolving. And besides, efficiency consideration also appeared to favor the ANI technologies. We took that into account. Like I said, that the underlying analysis is consumer welfare, which was providing ease of booking and ride tracking. Besides, there was an exponential growth in the market due to presence of taxi aggregators. So the Commission, we closed the matter for want of dominance. Without dominance, you cannot speak of predatory pricing. So we closed the matter for want of dominance and did not examine the issue of predation. You also spoke of whether online and offline markets are one or they are between. Again, as I said, that this is the regulatory understanding evolves with the manner in which the economics of these markets are working. And while in an earlier case, we had taken the view that the online and offline market in a particular instance were one, recently we have taken a view in a online travel platform case that the online and the offline markets will have to be will need to be looked at separately, and we're looking at the online market separately. So it is a dynamic view that needs to be taken. There is one concern about data-driven acquisitions. So this was about the antitrust aspect on data-driven acquisitions. There are mergers where it's driven by the desire to acquire the data and or kill a competitor, both those. So on this issue of data-driven acquisitions, where many large tech companies are acquiring other companies with the primary motive to have access to the data owned by the firm, what was happening was that they were not falling because we have thresholds. We have merger thresholds in terms of assets and turnover. So they were falling below the minimum prescribed thresholds, and many of these mergers or acquisitions would not come within the ambit of the Competition Commission. We could not analyze them from a competition perspective. So the Competition Law Review Committee, the CLRC, in its report has recommended that value thresholds, deal value thresholds, they go for a huge value. They may not have assets, they may not have turnover. So the deal value thresholds for mergers and amalgamations taking place in the digital sectors may be looked at and may be considered and may be brought in through subsequent regulation. Finally, considering the developing nature of the Indian economy, it is correct to say that the competition law cannot be seen in isolation from the development goals of a country. That is not our intention at all. Pursuit of static efficiency, where competition process aims to achieve immediate welfare objectives with no long-run trade-offs, may not be able to serve the objective of economic development. Development of online economy is backed by innovation based on big data, artificial intelligence, and online platforms. So we have to allow emerging monopolies to be rewarded for their innovation. And that is a tightrope walk that the Commission does. We keep in mind their dynamic efficiency and long-term productivity implications. This emphasis on the dynamic aspects of change and recognition of the central role of the entrepreneur may be in direct conflict with the price theories focus on static consumer surplus. But it is important to ascribe a dynamic view to competition, and concentrated markets will have to be traded off for consumer benefit. The law, quite consistent with the consumer welfare standard, prohibits, as it stands today, prohibits the conduct that creates or is likely to create market power for reasons that are not related to economic efficiency. It allows and consideration of only economic efficiency issues. To ensure that markets online do not develop in ways that can harm competition and consumers, we need to act quickly. And for that, we need to, as I said, understand new markets and new technologies. And we as a Commission are engaging with stakeholders and experts through market studies and regular knowledge sharing sessions to keep abreast of market developments, new frontiers in technology, so that we can quickly craft an appropriate response to any changing situation. Like I said, we have been modifying our view in terms of how the market is panning out. We also use these market studies as guidelines for our advocacy priorities and sectoral advocacy priorities. With that, brief discussion of how we in the CCI are looking at many of the issues that CUTS has raised today. I thank CUTS once again for this opportunity to be here, and I look forward to the subsequent discussions that will be taking place on this.
Thank you very much, Dr. Verma, for a very good tour de force, I would say. You've dealt with all possible issues which you're going to grapple with. And our request, George?
Yeah, I'll keep to the time. My name has been introduced. First, I may say 1 minute to talk about COMESA. It is the biggest regional economic community in Africa. It has got 21 member states, running as far as Egypt, Tunisia, coming down to the islands, Madagascar, Comoros, Seychelles, and in the Central Africa, we have Zambia, Zimbabwe, Malawi, and Congo. So the coverage of the market, of the common market, is the widest. And it is the only economic community out of the 8 economic communities in Africa which has got a regional competition regime, of which I hate that regional economic regime. I think that is for what COMESA is. Over 520 million consumers. When we say 520 million people, all these are buyers, they are sellers, they are what constitute the commercial or entrepreneurship in the common market. All these people are affected by the topic we're talking about online economy. But again, first we start with the point that this is dominated by giants who are not resident in the common market. That in itself tells us that to regulate somebody who's outside the common market becomes very difficult. When did competition come about in the common market? That was 1992 and 1994. And the first, if you do recall, project which was conducted in the COMESA or in Africa was the 7-Up project. And I'm happy to be here that it was CATS who did the first meaningful study to look at the level of competition in the common market, Africa generally, and trying to create the advocates, the most instrumental advocates too, which took place during that time when we were starting our competition authorities. Now, coming back to online, what comes to mind really, most of it has been summarized by Pradeep. I think he was supposed to speak last to summarize our discussions, but he opted to speak first. Because he has summarized everything. It is the design of our competition registration. CATS was involved in designing competition registration, and at no time I sat with Pradeep did he talk about online economy. When we were enacting, establishing the laws in our member states. And for over 15, 20 years, nobody was talking about online registration. I'm saying this just to inform you that we are talking about new issues which were not captured by our national registration, and up to now not captured. There's been revision of laws, but even then, the second revision, we haven't captured these online issues dealing with e-commerce. Very few countries are told they've got a specific registration. Coming into consumer, I was talking to Alan Asha just before we came, that the laws dealing with consumer issues, in fact, are more worse than the competition laws, because they just deal with misleading advertisement, foreign substance in water, Coca-Cola, that type of thing. And look at the people in the enforcement of consumer laws. Mostly are NGOs. And they don't have even the membership. You do recall when we went to Uganda with Pradeep, we went to visit this consumer organization. We found that it was a man and his wife. That's the only membership what us had to that group. So enforcement on consumer, in fact, it is so weak that the topic we are talking about, they've got no clue what we are talking about. And it will take a lot of time before they even bother to venture into these online companies. We've been in existence for almost 9 years now. We had no notification involving online e-commerce. The only thing near to it, there was the Uber Kalin notification which came about, I think this year. It has been notified with the COMESA Competition Commission as well. But I can recall around 2015, there was the Facebook WhatsApp application measure, and it was not notified in any country in Africa, unless if you don't have the statistics or knowledge of that. This shows that we were not ready then, and we are not ready now. Do we have the resources, or do we have the competence to look at these issues? Just as you said, Madam, that we don't have even the tools to do a good job in dealing with these issues. And you know, when you don't have the tools, the competence, what do? You injure the market in the name of assessing. Little knowledge is always dangerous. Whilst we may saying that we are regulating the market or safeguarding the consumer, we may end up injuring the consumer. Coming to competition authority, there's also a conflict which is real because of the relationship now we have with sector regulators and ourselves. Take for example, I think when we open to the audience, I think Dr. Mwencha will be able to talk about M-Pesa in Kenya. They so much acclaimed. You find that the competition authority have something to say. The banking sector regulator has got something to say. And we are writing a document whereby the banks are complaining that this mobile money, they are not subjected to regulation like us banks. So it is unfair competition with them. We've got Airtel money, we've got several, all the mobile phone operators now, they are in money transaction. And they've quite taken a niche of the customers. Now, what am I saying is that the region, as far as COMESA is concerned, as well as Africa, we are relatively, we have got to do what we are doing here to understand what e-commerce is all about and how it affects the consumer and how it affects competition. And not much time has been given to this type of study. When I received the invitation for Pradip, I went to the internet. I found that the EU, they are quite doing a recommendable job. And India also are quite doing that. Under the Continental Free Trade area, there are some provisions involved relating to these issues. But coming now to be practical, most of our national competition authorities, they just deal with traditional issues, restrictive business practices in their traditional form, measures in its traditional form, consumer issues in their traditional forms. As a result, they are reluctant to deal with these matters. So our sector regulators, they are also reluctant. They are more concerned with the licensing part of sector regulation than dealing with the market issues. And the limited resources are affecting us, national competition authorities, that now, as I'm talking, most of the national competition authorities in developing countries, they are not receiving money from government. Neither is there any enforcement involved. So all these are issues which makes us not to give the necessary or the appropriate response to the new issues coming on the horizon. Another challenge taking place is that whenever in the developing countries or in my member states there's something akin to this type of e-commerce, they are quickly bought out by the giants. I think Kenya, there was a young man who came up with something akin to this, and he was bought by one of the M-Pesa itself. So we don't have industries growing in this sector. Hence, the dominant companies continue plying our markets. And they are located outside. So even when we see some abuse arising from what they are doing, it becomes difficult to investigate them. And after all, their investment in our territories or in our markets is so low that they don't care about what we are saying. They'll just shift from one country to another. We are lucky that COMESA, we've got a leverage because when we act, we've got this common market. So when we talk at least multinational, they listen to us. But countries are acting individually. There's nothing. You don't recall, Pradeep, in your report, 7-Up about Zambia, the measure of Pricewaterhouse, the accountant firms. When we rejected it in Zambia, they didn't mind. They just went and set up in Malawi and Zimbabwe, and they continued operating in Zambia. You can't stop them. So those are the major issues as we discuss today. We look at the abuse practices of these global digital platforms and the measures taking place, do we have necessary tools? Are we talking about coming up with a new toolkit, as Pradeep mentioned when he was opening? Because the tools we have now will be cheating ourselves if we said we are ready for them. We are not ready, we haven't been ready, and we are doing nothing about it. Unless if something is skipping in my mind. Recent competition cases show that competition law frameworks and enforcement can be adopted. We have to come up with new models to deal with the digital platforms. If we don't do that, we're in trouble. It is a wave we cannot stop. We've got to look at our laws, and if there are people here who can assist, we need to come first with a model law which deals with this issue, which we can sell out at national and regional level. The Europeans have gone really a long way, and I think my friend Alan Asha will talk about Australia. We always admire Australia, how they move, they trail this type of new developments, new horizon. I can see Pradeep wants to speak again.
No,
Okay.
no, I don't want to speak again. I would like you to wind up.
Wind up, okay. I think I'll continue when it comes when open
No,
up.
no, you save your ammunition for tomorrow.
Yes, yeah. So that is a snap view of what is happening in commerce, and actually it's what is happening in most developing world. That we've got to pay attention to these new issues coming as regulators of competition, law, and consumer welfare. Otherwise, we're betraying the consumer at the end of it. Thank you very much.
Thank you, George. Just my own understanding and knowledge about the Africa competition scene is that they at least have a coalition of kind of a network of competition authorities. The opportunity of networking and learning from each other are much higher than many other parts of the world. You underestimate the strength of that particular network that you have. I request Jay. Please speak. I forgot to mention that, but Jay Panda is also the National Vice President of BJP, as I said, rather than being the spokesperson.
Thank you, Mr. Mehta, distinguished co-panelists, distinguished guests and delegates. It's a real privilege to be speaking at this event. We are at a very significant tipping point. Looking at how we are at a very significant tipping point in the confluence of these major themes of how do we regulate for competition, how do we regulate a global economy that is increasingly going online, and how do we deal with that with the particular challenges of developing nations. Competition has been well understood in modern free markets as being one of the key ingredients, and if you go back 100 years in the what are now the developed economies, we've seen that in basic core sectors such as oil. There was a line of thought for some years that somehow the internet makes everything different and that the same rules don't apply. Whether it comes to taxation or whether it comes to competition. But 2 decades on, it seems many of the old rules of economics do actually apply. And the developed nations are indeed looking at the very big global tech giants with the same kind of lens as their predecessors used to look at Standard Oil and others. In India, we have the additional challenge of huge scale which of course, the flip side of that coin is that it's also a huge opportunity. Challenge because everything that we do, when we hear what our friends in Africa and other parts of the world are trying, gets magnified that much more. In terms of the digital economy, this year we are at about $181 billion in this country. And our whole economy, of course, is knocking on the doors of being 3 trillion. We have a vision, the Prime Minister's vision, and looking at the macroeconomic growth rates, not just a few quarters, our aspiration is to reach that in the next 5 years of $5 trillion. And our estimation is that fully 1 out of 5 of those $5 trillion would be from the digital economy. This is very, very significant. Yet another of the challenges that we face is the overlapping of many regulatory authorities. We have the Competition Commission, we have regulatory commissions for telecoms, and sometimes they overlap, and sometimes other such commissions overlap with each other. This is not unique to India, but when you are at a nascent stage, growing very rapidly with a new landscape that's new for everybody in the world, it becomes extra challenging for a country which is not yet a middle-income country. We are knocking at the doors of being a middle-income country, but we are not really a fully middle-income country yet. We have resource constraints, we have bandwidth constraints, we have constraints of having adequate number of qualified people to serve as regulators, and so on. Yet, we are at a situation today where we have 54 would-be unicorn companies, out of which about 17, I think, or 18 already are unicorns. They are valued at $1 billion or more already, and a total number of 54 on the horizon in India. This is the third largest number of startups in the entire world. So this is what adds to the scale and the complexity of the challenges that we face. As Pradeep Mehta mentioned, I introduced the first bill in Parliament, a private member's bill. It was not just on privacy, it was also on data security. And this is a topic that's a hot button topic, because over the last 20 years, we've had huge scaling up of our digital economy, as I mentioned, coming up to $181 billion. The number of financial transactions that are happening, and in particular, over the last 5 years, with the world's largest biometric system, which is the national ID system, Aadhaar. It had a lot of resistance from many quarters, but it is transforming our economy and governance. A statistic the Prime Minister shared just a few days ago at a major national conference is important to cite here. He said there were 80 million fake beneficiaries of government schemes that have been weeded out because of the deduplication of biometrics of Aadhaar. 80 million people who, some of them had never been born, but had apparently been receiving government benefits all the way through to retirement. It's just how leakage used to happen in the system that has got weeded out. Now, in my bill, I had consulted many stakeholders. I think it's illustrative. It's one cog of the whole picture of regulation and online activity and some of these concerns like security and data privacy, but I think it's illustrative. Trying to match the needs and desires of industry, of users, of activists, and of individual citizens can be extremely challenging. So there are those activists who want a very ideal world of 100% guarantee of privacy. We can't really have that. We are not living in the 16th century, and it's not possible to live a hermit-like life without using the accoutrements of modern 21st century life. We have indeed, as a society, agreed to give away many of the aspects of confidentiality and security. We use apps and download apps all the time and mindlessly sign the release contract. For what? For convenience. Now, today, if you were to say that I don't want to use Google Maps, I don't want to go to the airport because there will be scanners. I don't want to drive in the city because we have CCTV cameras, which as a society for a couple of decades around the world we have been accepting. It becomes very difficult to live a 21st century life. So the answers I came up with in taking input from all these sectors is that privacy indeed ought to be a fundamental right, although the word privacy is not mentioned in our constitution, but it can be derived from the definitions. But that there have to be specific exceptions. They have to be narrowly decided, such as national security. But they can't be wantonly used. They can't be misused. They have to be very, very narrowly defined so that they meet a certain standard. I'll cite, I was very gratified that our Supreme Court judgment endorsed exactly this line of thinking, allowing 5 specific areas of breach of privacy with very specific conditions being in place. So when it comes to national security versus privacy, for instance, we have a very interesting dilemma. Now, in the old days, in the US and other countries, if you wanted to wiretap somebody, you have to have some kind of primary cause, prima facie cause, and you have to get a judge to give you an approval to do that, a warrant to do that. In the online world, if you have a terrorist threat, you may not have the luxury of trying to process a warrant to snoop on somebody. So how do you do it? One way, of course, as has been working, it happens in the US, it happens increasingly in many countries, the UK, in India too, is that you have supercomputers crunching billions of bits of data, SMSs, texts, emails, and they cover metadata. They don't invade your individual privacy, but all these billions of messages are being monitored and crunched by algorithms. And if you, this illustrative example I use is that we know that RDX is an explosive that is often used by terrorists. Now, you and I may have an academic interest in RDX. We may occasionally Google it or email somebody about it. But if from a particular IP address, the word RDX comes up hundreds of times in a week, that ought to be prima facie cause to allow the authorities to dig deeper into that and explore. So these are the sort of norms that we need to come up with to deal with the challenges of regulating an online world. Now, when it comes to economic issues, we have many challenges ahead. One of the tugs that we are facing today is, should we not follow the liberal market, free market-oriented, globalized model that has prevailed for so many decades since the Second World War when it comes to our digital economy? It is a legitimate question to ask, however, that should we not look at what the alternatives are, because that global order isn't exactly in the most robust condition today. Look at what China does. We may not like the way China governs itself, but by creating certain restrictions, by localizing data, by creating a silo, if you will. Now, normally we would think that in economies we shouldn't be creating silos. We should allow free flow of data and free flow of transactions. But by creating silos, have they not created global giants which contribute tremendously to the Chinese economy, contribute tremendously to their GDP and their clout around the world, not to mention the millions of jobs that they have created? So this is a tug of war that we are contemplating in India as to, should we be going in for things like data localization? There is a strong argument for it. There are some arguments against it. Should we be championing certain sectors or certain organizations that reeks of industrial policy? But we are not strangers to industrial policy in this country, and it seems to have worked in certain areas. And as I said before, that free-flowing, globalized environment is not what it used to be. So we should look from our point of view, from our own national interests, and with our own capabilities at all the options ahead of us as we decide on this. It has implications because when what is going to be the world's third largest economy decides on these policies, it's going to have a very big impact. There was a reference to European regulations. So if you look at, for example, GDPR, I remember just 2 or 3 years ago, in my discussions with various stakeholders, there used to be tremendous opposition to GDPR. Companies coming and telling us, policymakers in India, that look, you're going to squelch all competition. So on the one hand, you have one extreme, you have something like GDPR. On the other extreme, you have something like China. We do have to find a balance that provides as free a marketplace as possible. If we are not going to get stuck at 17 or 18 unicorns, if we want to aspire to hundreds of them and to create millions of jobs. And yet, at the same time, we have to look at the realities of the world ahead. In coming to my conclusion, I would like to say that we have to look at large companies differently than small companies. I would cite one illustration and then end my presentation. So, one of the large 6 or 7 major tech giants around the world have become like utilities. Most people can't live without a Google or a Facebook, practically, not just for their posting to their friends. Facebook is used for your identification, verification. Google is used for navigation and so forth. Now, if they were to use a stringent condition that if you don't give me your so-and-so data, we will not give you service, I think regulations should prevent that. I think regulation should require that these giant companies should only seek, with the consent of the user, whatever data they actually need to provide that service. If you don't need location service, you can get it only with the consent of the user, not otherwise. But if you have exactly the same standards applied to startups, you'll have a problem because startups don't have those revenue streams. Startups, in fact, do need all kinds of data to fund their business model, and that's what creates innovation. Now, if you apply the same standards, you will actually end up squelching innovation. But if you allow that startups can acquire all kinds of data from you, even some that they don't need, but as long as it's transparent, because they can sell that data and raise some money, they can say that, look, we're going to give you this service, we want this data, but we also want this data from you. And if you consent to give it because it's worthwhile, perhaps we should allow it because you can live without that service from the startup. It's not like you can't live without them, as you can't really with some of the big ones. And yes, indeed, as Madam was saying, a minimum size, a floor, becomes a very fundamental issue in deciding what kind of standards you want to hold these companies to. So in conclusion, I would like to say that we are looking at a very exciting and challenging road ahead as what is being defined as the new India. And many of the things that we are doing are being watched around the world because it will have a huge impact. Can be used also, the technologies that we developed, the services that we developed, not just for India, but around the world. I wish this conference the very best for this year and going forward. I'm sure the deliberations will be very interesting. I look forward to getting feedback on all of them. Thank you very much. We know that CUTS is doing very good evidence-based work that our government is getting more and more focused on using evidence-based policy making. This will be all very useful for us. Thank you very much.
Mr. Jay Panda would like to leave. He has some other commitments which he has to undertake. But he'll take a few questions if anybody would like to raise. Yeah. Please identify yourself.
Hello. Good evening, sir. So my name is Aditya Kumar. I actually work in the investment promotion agency of the Government of India, which is called Invest India. So we deal with queries of a lot of investors about these questions, and we try to follow the government's understanding as well as the investors' understanding to propose the a possible way ahead to the government departments. I just wanted to ask your view. For example, when you said that for startups you are in favor of allowing them access to data, but for big companies we need to, the law should not allow them to capture all the data which is not required specifically. So how do we sort of come about the distinction where we should stop? So for example, should it be size based or should it be time based? So this is a very active debate in a lot of such debates which are going on. Should we stop a larger company from certain freedoms we afford a smaller company, or should there be a time based thing that after 10 years, whether you reach a big size or you stay small, you will not get these freedoms, you will have to give them up?
Should I take some more questions? Yeah. Alan. Yeah.
Alan Asher from the Foundation for Effective Markets. Just to add to the previous question, it's, I think, a bit of a warning about the problem of building national champions, favouring small business in a startup phase, allowing exceptions for national security and those sorts of things. These are arguments made over many years to give special treatment to all sorts of things. In my experience, they almost always act against the welfare of consumers, not in favour, and for the very same reason that in trade policy, giving benefits and inside tracks to some companies usually fails because they don't have the need to compete effectively for their business. They're able to rely on that sort of monopoly protection. So I guess I just say that's something that we should bear in mind and treat very skeptically, especially things like national security exceptions. You can find every single reason in the world to break down people's protections by simply invoking the security mantra.
Thank you. Yeah.
On this issue about the small and the large, I would like to caution a bit, because there's a more fundamental issue that should you allow a company to gather data for sale? Because then the question of ownership of that data becomes very critical. Is the individual owner of the data that pertains to her, or somebody can actually extract that from you under duress of sorts for sale or commercial use of that data? I think that would cause that distinction is important, because you cannot say that I don't need the data for my business, but I want to use it for selling it. That I think is there is a moral hazard there. What is more important, I think, is that the government must move towards the common use principle for data. Whoever collects the data, that data should be available in a common depository for anyone who requires it for innovation to be available, whether it's on a price or in whatever which way. And the regulators must begin to look at that. I think that's a very critical
Thank you. Last question, Amol.
Good evening, sir. My name is Amol Kulkarni. I work with Cuts International. I just wanted to catch one issue that you had mentioned, which was that large companies, when they reach a stage, they may be called as utility companies, and they therefore need to be looked at from a different perspective. And this is also taken from what others also said. In our country, specifically in digital payment sector, we are looking at government-supported large companies who are being turned into utilities like National Payments Corporation of India, and they are perhaps not following the best practices of consent, informed consent and data protection, which you have been watching for. So given that what our experience in India with respect to what government is doing is at odds with what you have been suggesting, your views on this issue would be highly appreciated. Thank you.
So let me take the first, third and fourth questions together because they are similar, and I'll take Mr. Escher's issue about the cautioning on national security next. Let me clarify something at the beginning. I don't speak for the government. I'm not currently serving in government. And even though I am a vice president and spokesperson of the party, on these topics I'm speaking in my personal capacity, in my personal opinion, because the party itself is debating these issues. We haven't come to a conclusion on all of these issues. Now, very good question about how do you determine size. I think we need to evolve norms for that. Perhaps it could be time-based, but certainly it has to be size-based. I mean, if you don't take 10 years, but in 3 years you become a huge company where you are like a utility. That's what I did say in the beginning, that these companies are like utilities. Then it is a well-known concept of regulation, especially about competition, is that utilities need to be treated differently than just a normal competitive company. Now, regarding Mr. Mayaram's point, very right. Nobody should be able to take your data under duress. So that was my very point. If a very large company like a Facebook or a Google says that I actually need these 5 things from you to give you this service, but I also want these 15 things, otherwise I won't give you service, that is duress. Because it's very hard to actually live a modern life without many aspects of these large companies. Now, small companies are not in any position to exercise duress over you. They're innovating something new. They're coming up with a new concept which nobody has thought about, just like Google did 20 years ago, or Facebook did 15 years ago. And then it's up to you to be enticed or not, and even then it has to be by consent. And then you've raised a second very valid issue as to who owns the data. I think Sangeeta Vermaji was talking about this very issue, about data portability, data interoperability, and that's an issue I think that's been discussed around the world. That's the whole issue of regulating these tech giants, not just in India, but overseas as well, that can, should, and ought a user to be able to have the right to retain the ownership of his or her own data. There are arguments pro and con. Some of these companies will say that we've come up with ideas and services that nobody conceived and we should be able to monetize that. And yet we as individual human beings ought to have some kind of a claim on our data which contributes to that monetization. So I'm sure norms will be found, and India is not the only one dealing with this. This is something that's around the world. But when it comes to duress, large utility-like companies do have a very different ability to exercise duress rather than small startups. Now, Mr. Escher, just like the danger that you highlight, that using a phrase or an idea like national security, it can be misused, the other extreme is also equally dangerous. Now, we live in a country which over the last couple of decades has seen several tens of thousands of people killed by terrorists. 42,000 alone in just one state, and many others around the country. We can't pretend that national security is not an issue here. As I said in my speech, and I think we are saying the same things really, it should not be used wantonly. It should not, but to say that it should not be cited at all is not realistic in where we live. Now, how should it not be used wantonly? Fortunately, we do have checks and balances. We have a Supreme Court that often overrules government initiatives and has given a very measured sanction to the use of biometrics and very specific guidelines about what the exceptions can be. And in answer to that last question, why we're still seeing instances of perhaps not the best practices is because we still don't have a law. Now, the government draft of the privacy bill and the data security and privacy bill is still going through iterations and getting feedback from various stakeholders. We still don't have a law. We need to have a law, but fortunately, some of the alarms that had been raised in the last 2 or 3 years turned out to be fake. For example, we saw all these fake alarms about Aadhaar data being compromised. Not a single Aadhaar data was actually compromised. It just turned out some people shared their Aadhaar number, and if you just have somebody's Aadhaar number, it's not compromised. They don't have your biometrics, they don't have your many other things. It's just like 20 years ago, if somebody stole your credit card, they could misuse it. Today, if they steal your credit card, they just have the credit card number, but if you have two-step verification with a one-time password coming to your cell phone or somewhere else, it's usually not misused. So we have to be just as careful about over-exaggerating the problems as the possibility of wanton misuse. And how do we find the balance? Is precisely through events like this, to come up with white papers, to have the kind of transparent discussions government is having on the bill that is in Parliament and the judicial system. Thank you.
Thank you very much. An excellent speech and an equally excellent interaction after this. May I give you a small token of our appreciation before you leave? Right. May I now invite Amit Kapoor?
Thank you, Pradeep ji. So I think we are three of us who are between. No, we are three people who are between dinner and all of this. So perfect. So I'll try to be as short as possible. I'll start with the whole idea of what Mr. Panda was actually talking about. So there were three very interesting pastures that I really wanted to touch upon. One is what Mrs. Verma had actually said, what Pradeep ji had said, and what Mr. Panda had said. One is on the whole idea of global order, and there is this new global order that is there, and should we have a different regulatory principle and things, or should we actually have a new way of looking at economics? I fundamentally disagree with the very point that we have to fundamentally relook at the way economics is done, because if you really look at the global order, why things have really happened the way they are actually happening right now. They're happening for a simple reason that the competition law has not been working rightly. So it is not economics. The whole paradigm of when you talk about competitiveness is about movement of land, labor, capital, and now data. So if we do not do it effectively, prosperity will not really happen. You will not really be able to share the benefits across the world. In fact, what we are seeing today is the wrongful impact of how economies were being run, how large sets of enterprises actually got created over a period of time. So when you say large enterprises, when you talk about Googles of the world, or when you talk about Amazons of the world, or whatever, they are the large enterprises. Or if you really talk about Nestle's of the world, Nestle's, in fact, there are just 5 companies who effectively control 80% of the food brands that we are actually consuming. So if you really look at this larger set, there seems to be a fundamental problem in terms of like how competition law was actually getting used across the world. We need to actually get into a system where economics or the very aspects of competition should actually get played. Large number of players, large number of consumers or whatever, and that is what we need to fundamentally look at. So that's a missing point. Quite interestingly, let me just share a couple of numbers here. When you talk about the very disparity in the world or whatever, the large sets of companies, they were, until about 1971, they were growing at a certain rate, and the productivity of labor was actually about 91%, or so the wages of laborers were growing at about 91% at that same rate. But today, when you have a certain productivity rate or increase for what you call benefits for firms, the benefits that are going to labor are actually just about 11%. So what you're seeing is that there is a huge disparity or accumulation of wealth that is actually happening at the large enterprises. So we need to look at these fundamental viewpoints in terms of how we really answer these questions. In fact, the next thing that we really have to look at is another question that was about utilities. In fact, when you talk about utilities, like I think, how can we even think of Google as an utility? In fact, the moment, I think the problem within businesses of Google's and everything of the world, I have a huge problem with them. I think they have created monopolies in terms of saying, I get stuck to their ecosystem. And my problem is with that ecosystem itself. Why can't I really move from one ecosystem to the other ecosystem very freely? And it is not happening right now. I think the data actually is getting stuck. If I'm actually on the Apple ecosystem, I'm getting stuck there. If I'm on the Android system there, I'm getting stuck there. I think the way portability has happened in the telecom industry, we need to look at these sets of situations across the board. We cannot simply say that there are going to be different sets of rules for a data company or whatever. They need to make things free. And I think they should do it on their own instance. Because I think this is where, if you really look at it, data is actually being seen as a resource, and who controls the resource? Data has to be free, without a doubt, but it cannot get controlled by the enterprises. Right now, what we are seeing is that the data is actually getting controlled by the enterprises. And I very strongly feel about that. The next thing that you really did talk about was the whole issue. In fact, there were 3 or 4 questions that were asked to begin with. In fact, one of them was that, have regulatory regimes promoted economic growth? I think yes and no. Within the Indian context, no. Within the external context, yes. And when you ask me this question, how regulatory regimes actually stalled growth, I think there is enough evidence with us that it was the regulatory regime in India which stalled growth for ages. In fact, the whole idea of license Raj was a regulatory regime which stalled growth for a long period of time. It is only now that we have come of age, after 1990s, that we have had a regulatory regime which is instilling the spirit of growth, how we are really looking at it. That is where competition has happened, and so on and so forth. Without a doubt, fundamentally, it's always going to be competition which is going to create innovation. If you're not really talking about competition, innovation is not going to happen. It's just going to be a dead sphere kind of a thing. I'm not saying that IP is not important. IP is exceedingly important. Yes, that should happen. But the question is going to be, how much can you actually extract, and how do you control? Like, at what point, till what point in time can you actually control? The next thing that was about the understanding of consumer welfare. I think the question that was asked is that, do we need to revisit the traditional understanding of consumer welfare? I think Madam Verma had actually talked about it, and I think I fundamentally agree fully with her on the very point that you have to really create laws or competition policy which keeps the consumer at the center of things. You cannot actually have any other way in which things have to be looked at. Because the moment you actually say that I'm going to look at, because it's a question of demand side and supply side issues. In fact, when you talk about a supply side dimension, I think the problem is going to be that the policy focused on a structure of the market or competition and other things, it is not going to give you any sense of consumer welfare. It has to be consumer who has to be the central idea when you are really talking about it. I think if we don't do it, the exploitation of consumers could be absolutely stunning. In fact, we have seen evidence out here itself, because the moment you really look at it, let me bring a name of say an automotive company in India. It's a very minor issue, but then we really don't even look at it. The Indian automotive sector has not been innovative. They were not really talking about safety standards at all. It was the regulator who brought in the safety standards. It was the regulator who said, oh, you need to have seat belts, you need to have airbags, and so on and so forth. So it was a consumer-centric view. If we were taking a company-centric view, it would be very simple. No innovation was actually happening. We got stuck with ambassadors and Fiats for ages. That was a supply-side issue. And then we have not really, we have to look at those sets of ideas as well. But having said this, I think the other question that was raised was something very important was, can we look at sustainable inclusive development with the very idea of competition? Absolutely, yes. But there are 2 or 3 things that we need to actually look at. One is that we cannot put everything in the basket of the regulator. I think this is where firms will also have to change themselves. It is very easy for us, in fact, to really go out and say, oh, it's the government policy, the regulation, the regulator who's screwing up the system or whatever, without understanding or questioning as to what the firms are doing, because it's also a question of firm conduct and performance. And when you talk about firm conduct, I think it's been appallingly bad in many situations, actually. It's not been that the firms actually conduct themselves in a far superior way as to what is their purpose, what they want to do. Are they really doing something for society at large or not? It's not going to be only about regulation. It's also going to be about how firms create their business models. How do they really go onto the market and solve problems? In fact, quite interestingly, I think there is a CSR law that we have in the country, a regulatory thing. I disagree with it, but I think if you remove it, I think it's a better chance that firms might actually understand that they have to look at social issues much better. Because today, when we are talking about the world today, it's about economic objectives and social objectives. How do we really bring these things together? But at the end of the day, I think the question is, like, when you talk about developmental implications, they can all get solved through technology in a very, very interesting way. And, in fact, Jay Pandaji did talk about the governmental programs or whatever, but I think a couple of points, like say the Jan Dhan Aadhaar mobile as a jam trinity that the government has been talking about. India has seen the highest change in the last 5 years because of reduction in information, what I call asymmetry. The second thing was, of course, how this technology has actually been able to use to really push forward for financial inclusion. Without a doubt, it has actually been one of the biggest things that we have actually seen. But the question is that this happened because there was large competition. There was a new player on the block, or there were these new firms which are actually talking about like Paytms or whatever. There was something very stupendous that was actually happening in the market. But now the question is, like, if you really look at it, but there are dangers that we need to be really wary about with these technologies. And I would like to bring in this whole societal issue at point, because if we really don't look at this, we are really going to be facing a huge problem. I think this is also a point in time wherein we are seeing a huge reduction in IQ of people in the world. And how do we really, in fact, I can see some nods, people saying, no, it's not true or whatever, but I think there is clear evidence. In fact, we are actually gauging information on your mobile as intelligence. Without a doubt, it's not the right way of looking at it. It's a question of how people are consuming information, what is happening, and how intelligence is being looked at. There are going to be severe issues as to how things or how consumers are going to change, how mature they are going to be, and we will have to fundamentally relook at things. So that is going to be one point. But then that is actually going to have a huge impact as to how education is given to people, or how we really look at scaling of education solutions and so on and so forth. But these are all issues that will come across to us in terms of how we really regulate these markets and move forward. But at the end of the day, the last point that was, what is the role of competition and regulatory regimes for the future? I think absolutely high. If we really do not look at how economies are going to evolve, or how markets are going to evolve, or how industries are going to evolve, I think the fundamental problem always happens is that the regulator is always a step behind from how the industry is evolving. Because industry actually evolves much faster. The regulator is quite a lot of times is a post facto understanding. And there's nothing wrong in it. I think because that's the nature of how industry evolves or whatever. The question is going to be that how do we create situations wherein the regulator becomes far more, what I call the level of information that they have becomes far more robust and really take it forward. And then, of course, last but not the least, I think when you're talking about regulation, we should also talk about regulation in a very interesting way. Right now, when we are talking about politics, there was a whole huge political debate that was happening. There is severe lack of competition in politics. The question is, my question to the regulator here is, how do you push competition in the political parties? Can you do that? In fact, it is very, very important that we have competition. In fact, on the Herman Hirschfeld index, if you really look at the number of seats that a single party has, it would actually be a perfect case for a regulator to see. But then those are questions that somebody can answer. But just a few pointers that I thought I'll share, and I hope I did keep my 10 minutes, Pradeep ji.
Amit, there are a lot of competition issues outside the classical area of economics, but we can't get into that at
Absolutely,
this point of
absolutely.
time.
But then, of course,
Except
thank
to
you.
say that thank you very much. May I now invite David Gerber? And you can save your ammunition for tomorrow also. I mean, you don't have to exhaust your ammunition.
No, in fact, I'm thinking one of the last speakers anyway. I will try to keep this even shorter than I had thought. And we've heard all kinds of wonderful discussions on important issues. My thought was to simply move back a little bit and put a little bit of perspective on something that we've talked about. And not to be specific about it at all. I will have a chance to be a little bit more specific tomorrow, and that's what I plan to use this opportunity. So my thought is just to take a look at the tools that we've talked about. So we've basically been talking about economic tools. We all know that there are issues with other kinds of tools, but we don't really pay much attention to where they came from, what they are, whether they have any history of importance. And I don't want to do anything more at this age of the game, since we're all expecting to eat dinner, I guess, not before too long. Just to point out a couple of little pieces of the story. So if you look at the tools that have been used, the U.S. Has used basically the economic effects tools now since the late 1970s. The U.S., of course, is not exactly a representative country. This is a stable, well, it was relatively stable anyway. It's a well-off country by any means, I guess. The competition, people have a lot of money, they have a lot of technology, they can do a lot of things, they have a procedure that have a lot of factual material. As you look at most developing countries, you begin to say, is that a particularly good reference point? And the other reference point out there, however, is the European developments. And when you add in the European developments over time, you begin to think, well, what is big data doing right now? Essentially, it seems to me it's illuminating the differences between two perspectives. One, the economic effects perspective, and the second, which is basically originally associated only with the United States, and much broader now, of course, but that perspective was initiated in the United States. And the European perspective before the last few years. And big data seems to me to say that other kind of toolbox that was used to move Europe from a state of what would be called today underdevelopment, right, very weak situation for most purposes, in many ways very similar. If you go back to 1950 or even further back, you look at Europe, it was very close in many ways to what we have in the developing world now, especially with regard to things like competition law. And so if you begin thinking about that, when you say, well, big data is now leading to a controversy on the global level between those people who want to stay very focused on the economic effects and those people who want to look at it a little bit more broadly the way the Europeans did. And some people fail to pay much attention to these days is that that the concept behind what the Europeans did, which turned out to be very successful in Europe, was a power restraint concept, right? The notion was that we control power being used in an abusive way, and that control leads to benefits for consumers, but also leads to benefits for the economy. When you begin to look at the big data issues, they focus continually on that sort of breakup, right? Privacy issues in Europe as part of competition law. I'll talk a little bit more about it for a few minutes tomorrow, but the United States and the EU having this big issue with regard to big data. And one of the factors involved is, well, should you have a broader concept of the tools that you use in competition law? Or should you have a very narrow one? Having a narrow one has great value. It has the capacity, it keeps things under control. Having a broader one may allow you to do things that you can't do with a narrow one. And I think what I'm going to do, given the situation, is just simply suggest that in the approach to the problems that we have, and from the perspective of the developing world, it would seem to be important to be thinking about the kinds of tools that are necessary, where they can come from, what kinds of consequences they can have, how they can be developed for big data purposes. And when I look at this, it seems to me that some pieces of the perspective, the aspects of the development of competition over the last 100 years have been overshadowed and marginalized and maybe are extremely potentially relevant in the big data debate. But I'll talk about some more specifics tomorrow.
Thank you, David. Thank you very much. May I request Dr. Mayram, Arvind, to please.
This has been exceptionally interesting, incisive session. It's the first session, which is setting the pace for what will come in the rest of the sessions tomorrow. So I will not speak too much on that. I need to thank everybody, that's what I've been told. But I want to just raise one issue which perhaps we will talk about in at some length tomorrow in the last session. But one issue, especially because Ms. Sangeeta Verma is here from the Competition Commission, I think it's important for her to to also ponder over it as. Whereas we will be speaking a lot on competition and how to deepen competition, definitions are still a huge problem. And the overhang of these definitions on the larger economic system have very grave consequences. We have seen this in two cases. For instance, coal is one very classic example. The coal blocks which were cancelled, 59 coal blocks which were cancelled by the Supreme Court. And then, of course, the telecom is the second big elephant in the room, which is any day going to go on a rampage. And both these and many of these, which have a great overhang on the banking system. We need to be extremely mindful of the fact that at the end of the day, especially in the case of telecom, we've seen with the series of things which have happened, the overhang on the banking system, which is already there, is going to cause much more grievous hurt to the consumer. We have seen at the moment the collapse of consumption in the economy, and in the Indian economy, is primarily because of the drying up of the credit to the consumer. And that has happened because of the overhang on the banking system of all these pronouncements which have happened on many of these economic issues in the light of competition, transparency, etc. So I think we need to find this balance somewhere, and I hope we'll discuss more about it tomorrow. I want to thank all the panelists who have been here, starting with Ms. Sangeeta Verma, who's member of the Competition Commission of India. It is actually heartening that she's continuing with the tradition of Competition Commission, engaging with the civil society to be able to look at issues when she's not sitting on the bench, which gives a different perspective. I would also like to thank Mr. Lipimbil, who is Director and Chief Executive Officer of COMESA Competition Commission. I think he brings a huge amount of experience from Africa. We have also Mr. Amit Kapoor, who is also from a civil society space, Chairman of the Institute for Competitiveness. He always is very provocative. I really hope his question about competition in political space is taken up by some regulator seriously. Mr. David Garber from University, who's from Chicago Kent College of Law. Thank you for being here with us. Mr. Panda has left. And Mr. Pradeep Mehta, who has been holding fort for the last 40 years in the space of consumer protection and still going strong. I am quite confident that tomorrow there are several sessions, each one of them is going to be very interesting, and I hope all of you would be here with us tomorrow. Thank you very much for being here.
Thank you. Thank you, Arvind. And yeah, a little recall, when speaking about regulating competition in the political sphere, in a seminar one day, there was actually a demand that why don't we have a regulator for corruption? Because the corruption actually seeped in so much in our system, Arvind, that there are no benchmarks. You don't know what happens if there is non-delivery, whether the fellow will refund money or not. So I thought this is an important thing to